Everybody's okay with that?
Can you? 1 minute.
Sure. Yeah.
You're free to proceed.
Thanks, Brent. Mr. Chair, would you like to open the meeting?
Sure. I'm gonna welcome everybody to the March 10th, 2021 Parks and Shade Tree Commission special meeting. We're opening the meeting at 2 p.m. Welcome all the my fellow commissioners, and also Glenn Mandalas and Liz Lingo from representing the city. This special meeting, I believe, is primarily one for training to discuss some of the facets of the current city code and how it affects the commission. So I guess without further ado, if there was any further ado, then I'll hand that off to Glenn Mandalas, who I think will conduct the discussion. Okay.
Thank you, Chair. Yeah, we thought today would be a good opportunity. We've got some new members. We've got a new chairperson to go through kind of the activities of the Parks and Shade Tree Commission and the appeal process that comes to you in all different shapes and forms. So hoping this will be helpful. Liz is here to ask questions of as well. Feel free to stop me at any point. The slide presentation isn't too long, but I want to be sure we're addressing questions that you have on your mind. So to the extent you have them, I'm happy to stop, and Liz and I can address them. So unless anybody has anything before we get started, I'm going to share my screen so you can see the slides. Anybody?
Okay.
All right. Everybody able to see the presentation?
Yep.
Yeah.
Great. So the topics we're going to cover today are first, the evolution of an appeal. That is kind of how does an appeal come to the Parks and Shade Tree Commission? You're the body that decides appeals where a person believes they've been aggrieved due to the refusal of the city to issue a tree removal permit. I'm going to talk more about this, but basically, if Liz Lingo, as the city arborist, or whoever happens to be in that position, does not issue a tree removal permit after one's been requested, there's an opportunity for an individual to have that decision reviewed. You're the body that reviews it through the appeal process. So we'll talk about that, how an appeal starts and gets to you. We'll talk about the basics of an appeal, kind of the criteria for granting or denying an appeal. And we'll also talk about the hearing process itself. I mean, what are the certain steps that have to happen as an appeal takes place before you? So how do we get an appeal before the Parks and Shade Tree Commission? Here's the evolution. A property owner desires to remove a tree on their lot, typically on their private lot. We'll talk a little bit later about removal of trees that are on public property, city trees or street trees. But we're going to address primarily right now of the person who has a tree on their private lot and they'd like to remove it. Section 253.30 of the code says no person shall directly or indirectly cut down, substantially alter, destroy, remove, relocate, damage, or authorize any such act involving a protected tree situated on any land within the city of Rehoboth Beach without first obtaining a tree removal permit. So the baseline is no tree is removed unless a permit is obtained through the city. So we'll go back to our property owner who wants to remove a tree. The first thing we have to do under section 253.30 is ask the city for a tree removal permit. The tree removal permit comes to the city arborist, Liz, who we have with us today. Ms. Lingo will review and issue a tree permit when it is appropriate to do so, or she'll deny it if it is not appropriate to issue it. So the first question is, when is it appropriate for the arborist to issue a tree removal permit? And these are important criteria because remember, when an appeal comes to you, it's basically a person saying, I asked for a tree removal permit. The city arborist chose not to issue me a tree removal permit. I think that decision was inconsistent with the code and the tree permit should have been issued. So you're reviewing the decision of the city arborist to deny a tree removal permit. So it's important that you know when it's required that a tree removal permit be issued. And there's only 7 instances. Well, I shouldn't say there's only 7 instances. There's some other outside instances, kind of on the fringes, where she can issue a permit. But in general, these 7 instances are the basic and most important ones that the Parks and Shade Tree Commission needs to be aware of. So section 253.30 says that no tree removal permit shall be issued unless the city finds that at least one of the following criteria is satisfied with respect to each protected tree designated for removal. So here are the 7 instances. First, in the case of an application for a building or demolition permit or for approval of a subdivision, the tree is located within the net buildable area of a given lot as identified on the tree survey protection planting plan, provided that alternatives under 253.35F of this article have been considered. So if somebody applies for a subdivision and the lot layout is such that a tree falls in one of the buildable areas of those lots, the city arborist can issue a tree removal permit in that instance, so long as these alternatives have been looked at under section 253.35F. I'm not going to go through all of those. Basically, the applicant should have looked at other alternatives, ways to situate the lots to save trees. So that's a step that's supposed to happen prior to Ms. Lindo issuing, or the tree arborist issuing a permit under this section. Second, the tree is located within an existing or proposed public or utility company right-of-way, and relocation of such right-of-way or the use thereof is not reasonably practicable. So a tree has grown, it's in a right-of-way, even could be the city's sewer utility right-of-way, or could be Delmarva Power's right-of-way, and the utility company, for one reason or another, needs to remove that tree so that it doesn't interfere with the operation of the utility. That's an instance where Ms. Lindo, the tree arborist, can issue a tree removal permit. Third, the tree is located within an existing or proposed public easement, stormwater management tract, or facility, provided that only the minimum area reasonably necessary for the public service or use shall be considered for purposes of determining whether there is necessity for tree removal. So, for example, if you need to install a stormwater management pond, and that pond area, the minimum amount required still has to be placed in an area where a tree exists. Under that instance, this tree arborist could issue a tree removal permit. The fourth instance, and this one's an important one, it comes before you as a Park and Shade Tree Commission often because there's a little bit of subjectiveness, I think, in this criteria. So it's that the tree is located where it creates or will create a material safety or health hazard or nuisance with respect to existing or proposed structures or vehicles or pedestrian routes, and such hazard or nuisance is not innate to or commonly associated with the existence of trees in general. For example, lightning, wet leaves on the ground during rainstorms. So if a tree threatens a structure, in the way it's growing, or its root structure is such that it's threatening a structure or causing a tripping hazard, there's those sorts of instances could fall under this fourth reason for the issuance of a tree removal permit. But to be clear, the permit's not supposed to issue for things that are commonly associated with the existence of trees. And the examples given here are lightning. Somebody says, well, if lightning strikes this tree, it could fall over on my house. Well, that's something that's just commonly associated with trees, and that's not an appropriate reason to issue a tree removal permit. Fifth, the tree is located where it interferes with the installation, delivery, or maintenance of proposed or existing utility services to the lot, and relocation of such service is not reasonably practicable, except that a higher degree of necessity must be demonstrated by the applicant in the case of a historic tree. So if there's proposed utility service to a new home and there's only really one route that utility service can take for one reason or another, and a tree needs to be removed to allow for that utility to be placed there, that's an instance where a tree removal permit could be issued. However, if it's a historic tree and there's a special definition for historic trees, obviously they have some age on them more so than other trees. you have to demonstrate a higher degree of necessity. For example, it's probably not enough to say it's gonna cost a little bit more if I have to put the utility here versus over there. It has to be something greater than that sort of a necessity. Sort of like this is the only place the utility can go. 6, the tree is determined by the city to be dead, significantly diseased, severely injured, or in danger of falling. I imagine that this is an area that the city arborist often issues tree removal permits under. Trees just naturally die over a number of years, or they can become diseased, and those are appropriate instances to issue tree removal permits. And then finally, the tree prevents reasonable development of a lot that is otherwise permissible under city ordinances. However, a tree removal permit shall not be granted where the applicant has failed to design and locate the proposed improvements, demolition, or subdivision so as to minimize the removal of trees consistent with the permitted use of the lot, and shall be granted only after full consideration of alternatives under section 253.35 of this article. So that's similar to the other reason we looked at back on the previous page. But basically, if the tree is within a buildable envelope on a lot, that tree can be removed so that a dwelling or other structure can be erected, but only after other design alternatives that would perhaps save the tree have been considered. So those are the 7 criteria. And as you're listening to appeals, those are the 7 things you should be considering as an applicant presents. Are they demonstrating that any of these 7 criteria have been satisfied? And if they have been satisfied, then perhaps the tree removal permit should have been issued. But if you can't point to one of these 7 criteria in an instance or in an appeal that comes before you, then the tree removal permit, then the city arborist should be affirmed in her decision to not issue the tree removal permit. So the evolution of an appeal. So the tree permit was denied in our instance. The property owner wanted to remove a tree. The city arborist looked at the 7 criteria, didn't find that this tree fell into any of those 7 criteria, and the tree permit then is denied by the city arborist. At that point, the property owner who had the tree removal permit denied, has an opportunity to apply to the Parks and Shade Tree Commission and ask for a review of the city arborist's decision. And that's our appeal. You're reviewing the decision that the city arborist made to not issue a tree removal permit. So an appeal application has to be filed within 30 days of the city arborist's decision to not issue the permit. There's a $250 fee for the appeal to come before the Parks and Shade Tree Commission and have the decision reviewed. A date is established for the appeal hearing to take place. And prior to that appeal hearing taking place, the city arborist will issue a report covering the components of the case that's going to be before you. We're going to talk a little bit more about the report later, and Ms. Lingo might have a few things to say about it as well. So now you've got an appeal before you, and the question becomes, when can the commission grant an appeal? When can the commission authorize the tree removal in contrast to what the city arborist did, which was deny the tree removal permit? Well, your standard again is the same as her standard. Only if one of the 7 criteria apply can you authorize the issuance of the tree removal permit. So I'm drilling these 7 into your minds because it's the thing that I think you should be most focused on when you hear when you're hearing a tree removal permit appeal case. So the first one, again, we're not going to go through the whole thing, but again, if it's in the buildable area where a subdivision or a building permit has been issued. Secondly, public utilities, you got to be thinking about, does this tree exist in a public utility? Third, is it within some public service area, such as a stormwater management tract or a proposed public easement? Fourth, again, this is the one that I think becomes your focus many times, not all the time, but many times. Trees located where it creates or will create a material safety or health hazard or nuisance with respect to existing or proposed structures or vehicles or pedestrian routes. Fifth, the tree is located or interferes with the installation Delivery or maintenance of an existing or proposed utility service. 6, the tree is determined by the city to be dead, significantly diseased, injured, or in danger of falling. And then 7th, again, it's in that buildable area, and other design alternatives have been looked at already. But those are the only 7 that the Parks and Shade Tree Commission should be gravitating towards if a decision is made to reverse the decision of the city arborist. So here's the hearing process. How does it actually take shape on the day of the hearing? So the chairperson will open the meeting, generally give any remarks that he feels appropriate with regard to the cases that are going to be before you. Then when you open one of the cases that's before you, the city arborist will present a report. And that report, again, as I mentioned, you'll have it prior to the meeting actually happening. But in that report will be things such as why the tree removal permit was not issued, how much tree caliper is at issue. And that's important because if you decide to reverse the decision of the city arborist and allow the tree removal, then there's a mitigation factor or component that has to be considered. And does this appellant have to then plant trees to mitigate the removal that you've just authorized? That becomes a kind of technical process. The city arborist is typically good about including within her report how much caliper is being removed, how many replacement trees or replacement caliper would need to be planted to mitigate the removal, if any. So that's all in her report, and you might have questions for her about her report after we're done getting through these slides. So after the city arborist presents the report, there's an opportunity for you as members of the commission to ask questions of the city arborist. If something wasn't clear in the report, or if there's something that just wasn't addressed that you think is relevant to the case, those are all appropriate questions to ask the city arborist. After you're done with that process, the applicant will present their case as to why the tree removal permit should have been issued. And the same process will happen. You as commission members will have an opportunity to ask the applicant questions about things that they didn't comment on, or things that you find relevant that you want to hear more about. After that process is done, the chairperson will then proceed to open the public hearing. And this is an important part of the process because under the city code, you are required to have a public hearing as to each of these tree removal appeal proceedings. And a public hearing requires you to listen to members of the public, and it's necessary that you take those comments into consideration as you make your decision on the appeal. Once all the members of the public who want to talk have been exhausted, the chairperson can close the public hearing, and at that point, the case is submitted to the commission, and the commission begins its deliberations on how it's going to decide the case. Any questions about that process as to how you actually get from A to Z on opening and closing the case and having it submitted to you?
It's clear.
So as you're deliberating, at some point, a member is going to need to make a motion. The motion is important because if it's not made really clearly, the voting process can become incredibly confused. So I always advise that the motion should be made in the affirmative. That is a motion that would grant the appellant's appeal. Even if you don't want to, even if you're not going to vote that way, you don't have to vote in the same way that you make the motion. So you can make the motion just so it's set up in the right way so the voting is easier, and still vote against the motion. You can vote against your own motion. So in this case, a typical motion would be, I make a motion to grant the appellant's appeal. And that way, a yes when you're voting means yes to what the applicant has requested. They should be issued a tree removal permit. A no is a no to what the applicant has requested, and it's an affirmation of the city arborist that the tree removal permit should not be issued. Generally, the best practice really after a motion is made is for the chairperson, Chair Marker in this instance, to take a moment and explain the motion to the members of the commission so that it's extremely clear before the voting begins as to what a yes vote means and what a no vote means. I can't tell you how many times we've gotten, not this commission in specifically, but in all the boards and commissions that I represent, so many times we get into the voting process and the third or fourth person to vote, it starts their voting by saying, now what are we voting? What does a yes mean? And what does a no mean? And we have to go through it again, and it starts to get confusing. So make the motion in the affirmative. Preferably the chairperson explains the motion, and then the voting begins. In this particular commission, because your decision in some ways relates to private property, or in a lot of ways relates to the use of private property, it's always preferable that each member, while they're voting, explains reasons why they're voting. I'm voting yes because I think that this tree does create a health hazard or safety hazard to the left side of the building, and it should be issued for that reason. Excuse me. And the courts have said, like in these sorts of cases, the court isn't gonna root through a transcript to try to determine why a commission made a certain decision that it made. So it's important that when you're voting, you give these reasons. So if somebody appeals your decision, and we're at some point before a state court on one of these appeals that being appealed up the ladder to a state court, it's a much easier case for me to defend if I'm able to point to a transcript and say, well, when Ms. Downs voted, she gave these 7 reasons, and these these 3 reasons, and all these 3 reasons are applicable, and they're found in the code, and here's why. So it's much easier for me to make that case than to say, on page 17 of the transcript at line 52, there's a reference to safety issues, and I think that's why she voted. It's much easier for me to say, hey, judge, it's right here. When they were voting, they made very clear as to why they were voting the way they voted. So it's important to try and make that record. It's always appropriate as well when you're voting, if somebody gives some reasons for why they're voting the way they're voting, and you think they are particularly applicable, and you agree with those reasons, it's fine for you to say, I'm voting yes to the motion, and I'm voting yes for the same reasons that Ms. Downs voted yes. So you can rely upon another person's reasons. That's completely fine and usually appropriate. I like to hear it when it happens, because that gives me more ammunition in a lawsuit to be able to say, her reasons were all right, and they were relied upon by these other 3 members. So just voting sometimes seems a little bit, what's the word? There's a level of decorum that should happen when the voting happens, because that's going to be the focus when we get into any lawsuit that might occur. So if the appeal is denied, meaning that none of the 7 criteria apply, at that point, you're done with that case. The appeal has been denied, meaning that the city arborist has been affirmed and she made the right decision on that application. You're done at that point with that case. If, on the other hand, the appeal is granted, meaning that you believe as a commission that the tree removal permit should have been issued, then you have another step to go. And that's the mitigation piece of your appeal hearing. So under the code, there's a certain minimum amount of trees that have to exist on a lot based upon the lot size. And if a tree is removed, the general rule is that there needs to be mitigation of that tree removal. The city has taken a firm position that it wants to have a good canopy and keep that canopy. So even when it's appropriate for a tree to be removed and a tree removal permit to be issued, in many instances, mitigation or replacement trees are required in that instance. The city arborist, as I mentioned earlier, will typically include that information in her report. Basically, if you should grant this appeal, here's the mitigation that will be required. So you'll have to have that discussion as to what amount of mitigation is required. You do have another option in some instances, rather than just doing replacement trees as a type of mitigation. The tree allows the Park and Shade Tree Commission to grant a fee in lieu of mitigation. So you can authorize that the appellant make some amount of payment to the city, and that monetary fee in lieu of mitigation is then deposited in a special account that's used for the purposes of tree projects, tree pruning, all those sorts of things that the city needs to do on a routine basis. But the fee in lieu of mitigation says a fee in lieu of mitigation may be granted only by the Park and Shade Tree Commission through the appeals process and upon a recommendation from the city arborist. Before granting a fee in lieu of mitigation, the applicant, this is important, the applicant must demonstrate that the replacement of trees on the project site is not a viable option, because meeting the requirements of this article would result in undue hardship, that all reasonable alternatives relevant to protection and mitigation have been exhausted, and that granting a fee in lieu of mitigation will not adversely impact the intent and purposes of these regulations. So the default is that mitigation trees or replacement trees should be planted on the appellant's lot itself. Only after the appellant demonstrates that that you can't put them on the project site, it's not a viable option, should the commission consider a fee in lieu of mitigation under the code as it's currently constructed. Now, I'll pause for a moment to remind everybody that the city commissioners right now are in a process of reviewing several different versions or proposals to amend the tree ordinance that have been developed, one by the Planning Commission, one by the Law Oversight Committee. So through the years, there's been a lot of people that have looked at it and have made recommendations to the commissioners on ways to revise the tree ordinance. So although we're going through a lot of these provisions today, some of them could change. I don't expect that to happen anytime soon. I think it's going to be a process of going through, many recommendations before they get to an ordinance that they're ready to adopt. So just be mindful that they're going through that process at this point. So those were all the main topics that I wanted to cover, and it's a really general and broad overview of what you do as a Parks and Shade Tree Commission. There's lots more out there for you to do, but these are the appeals that generally come before you, and they're never, I shouldn't say never, but many times they're not easy decisions, and you struggle with whether it's an appropriate instance or not to issue the permit. So at this point, I'm going to stop sharing my screen unless anybody wants to see a slide again, but I will ask Liz if she's got anything she'd want to specifically discuss with you at this point.
Sure, I don't have a fancy PowerPoint, but we had talked, like, report-wise for me, you'll pretty much be getting one of three general formats. It'll be an appeal, which are few and far in between, but arguably the most serious of all the cases you'll hear. Then you'll have a fee in lieu appeal, which is what Glenn just brought up. But basically, I agree with the owner that the tree should be removed from the city's point of view. However, they can't meet the planting requirements, all that mitigation. So then it would be up to the Park and Shade Tree Commission to set the fee in lieu. Sometimes you'll get partial planting plans where they're planting 5 on site and have to mitigate 3 for a fee in lieu. And over the years, there has been a lot of discrepancy with those fees. And Glenn, you can correct me if I'm wrong, but previous to me even starting at the city of Rehoboth, so more than 5 years ago, the commission at that time set a fee schedule of $500 a tree with a maximum cost of $5,000 per 5,000 square foot lot, which is our standard lot size, and I think an overall maximum of $10,000. And whether or not everybody agrees with that, you know, is neither here nor there, but I don't know if it might be helpful if we set some sort of price range again, so that we don't get some people that feel like pay $125 a tree and some pay the whole 500, and they wonder why. I get those questions. Well, why did so-and-so have to pay only $250 and I paid $500? So I don't know, maybe you can chime in a little if that seems reasonable or if it should be on a case by case.
Yeah, let me just, so Liz is right. That was from a hearing in 2014. I actually have an excerpt from the minutes here, but as she described it, it's right. That might be an agenda topic actually that the chairperson, you know, may want to put on just to consider outside of the context of a case that's before you, you know, because it's more difficult to consider it in, you know, while you're trying to hear and decide a case, some decision that's going to apply globally to, you know, all the cases that come before you as fee in lieu of mitigation cases. Now there is, I think, one of the proposals that the commissioners will be reviewing, I think it actually includes a fee amount right in that proposed code. So this section would change, and there would be a fee that wouldn't be something that the commission could change.
Yep, I think you're right. I think they said it, and I think in one of them, it doesn't even come to the Park and Shade Tree Commission anymore. It's just an internal thing.
Right.
So we'll see where that, I can't remember which version or both versions. Although I've always felt that that's how it should be, is that we should pick the number. And if they want to appeal that number, so say we set the fee in lieu at 700 in the code, and they want to appeal that, then they could come to Park and Shade Tree still.
That's right.
To seek some special discompensation. And then the third report you would likely see from me would be removal of a city tree, generally removal of a street tree. Most of the time, I'd say they're construction related, a new driveway, stuff like that. But those really run the gamut, and there is nothing specific in the code that tells you as the commission when you should approve and or deny those requests. And they do not pay an appeal fee for those removal of a street tree. That is free. And it doesn't technically count as an appeal. I think it's listed as a case to get the terminology correct. But I think coming up, like whether or not we want to use the 7 criteria that were listed for private property tree removal and apply that to city tree, or what, so that you have kind of a firm baseline when those come to you, because that seems like it's the majority of the cases lately.
That's right. And I think that, you know, analogizing and saying that the 7 criteria, when it's a private owner still applying for the permit, it seems to me that it makes good sense to apply the same 7 criteria that you would apply to a tree that's on private property.
Yeah, I mean, I'm trying to think of all the cases we've had with that, and if there were any that it just felt like where I felt like the tree should be removed, but it fell outside of those reasons. And off the top of my head, I can't think of any. Most of them are pretty, like I said, pretty simple. The tree is in the path of a new curb cut or something, or the front walkway or something like that.
Right. Well, you have discretion though, Liz, on city trees to exercise discretion to be consistent with the city's tree management plan. And I mean, the 7 criteria don't always apply to your decisions because it's a management of the city's infrastructure. Or maybe I'm wrong about that, but that's why
I'm a lot stricter in what trees I remove from the city, to be honest with you, than these reasons.
Okay. Good. So questions, anybody? Oh, one thing before we do, one thing I want to mention is that, you know, generally, to the extent you can, one motion should decide the case. There should be a motion to grant the appeal or not, you know, grant the appeal. And I suggested that it should be in the affirmative always. But we've gotten before in the past into instances where a motion was not approved, and then you know, there's a call for a second motion or a third motion, and you start to, you know, sort of lose sight of, well, when has this case been decided or it hasn't been decided? I mean, generally, the motion should be made, and the decision on that motion should decide the case, and that should be it, and you should be moving on. So just be careful not to get in that kind of weird thicket where you lose sight of really what the case is about and has it been decided or not. Rachel, were you unmuting to ask a question?
I was. If you're up to questions, I was going to ask a question.
Sure.
So, Glenn, you and I have had this conversation, and I know it's a little bit of a sorry, my phone's just going crazy. I know this is a little bit of a topic that does come up from time to time, but as it relates to preparation, before we come, you know, to the meetings, and we know the cases are coming, and we know what's happening as it relates to the request, right? As it relates to that particular case. It has been a common practice, right, to go and see that site so that you know what is kind of occurring and what is being described. What is your perspective on that for the rest of this group, so that we just all can operate right the same way and consistently?
So a couple thoughts on that. First, site visits, going to the site and seeing it, I don't take issue with that, because I think it's hard for you to make a decision, especially, you know, is it really threatening something? Is it diseased? You know, it's hard to make those decisions without actually laying your eyes on the tree yourself, rather than photographs or, you know, some other way of looking at it. The thing about site visits, though, that the courts have said is that it's fine to do a site visit as long as it simply creates a foundation for you to decide the matter. So if you go see the tree, and from your perspective, you know, you can see now that it's leaning heavily toward the house. Some of the roots are starting to come up. You know, so that kind of informs what the circumstances are there. Then it's important that there's something that comes in to the record that will allow you to make the decision based upon what you saw at the site. So hopefully in that case, the appellant will say, you know, I think the tree should be removed because it's leaning badly. It's gonna damage my home when it falls. You know, so now there's something in the record that supports what you saw at the site, and you can rely upon that record evidence to make your decision. But again, your foundation was created because you were at the site and got to see it yourself. Now, if something happens that is not in the record, but you saw it during your site visit and you thought it was particularly relevant, and that's going to form part of the basis of your decision, at that point, it's important that you, during the process of hearing an appeal, that you elicit that, or you have that conversation with your fellow commission members to say, when I visited the site, here's what I saw, here's why I think it's relevant. And hopefully you'll do that perhaps while the appellant is testifying. So the appellant then can say, that's exactly right, and let me tell you a few more things about that. So then again, you're building that record. But to go and see something at the site and make your decision on the appeal based upon something you saw at the site that isn't discussed in the formal hearing and isn't in any of the documents that have been submitted as the formal hearing, that would be an inappropriate way to form your vote and cast your vote. It needs to be in the record somewhere, somehow. So that's one piece. The other piece we should talk about is ex parte communications. So if you're at the site, for example, and the owner comes out and says, I've got an appeal before you. Are you a member of the Parks and Shade Tree Commission? Yes, I'm a member. And they start to tell you all the reasons why you should vote one way or the other. At that point, you should say, look, I'm going to be deciding this in a public forum. I need everything to come in to the record in the appropriate way. So I can't have this, I apologize, but I can't have this discussion with you right now. You know, please be prepared and come to the hearing ready to tell us everything you want us to know. So, because the same thing, you might hear something from that individual that you rely upon, and if it's not made, if it's not discussed in the public hearing, then there's no chance for somebody who disagrees with that point of view to take issue with it and give the other side of the story. So those are some things you have to be thinking about as you lead up to these actual hearings that take place in the public forum. Other questions?
Just in addition to that, we don't have a right to just go on their property and look at it though, do we? I mean, we would have to get permission to go on the property. I mean, assuming that you would need to. I mean, obviously if it's in the front of the lot, you can just look at it, but we don't have a right to basically just say, oh, I'm on the Shade Tree Commission and I'm coming on your property, right?
That's right. There's nothing established in the code or in state law that gives you an automatic right to go on the property. So, arguably there could be a trespass claim if you went on their property, went in the backyard and was, looking at the trees. So best practices are to not do that. If you feel the need to do it, I suspect that Liz or somebody could reach out to the owner and say, would you mind if, somebody came by and looked, but we're not gonna have any conversations, but they just like to see the circumstances. We could probably arrange that.
Okay.
Other questions?
One of the things I was looking at another section, and this I think reiterates obviously all that you've covered up to this point, but the terminology I was just questioning in section 36 of the comprehensive tree regulations part of the code, where it says that I'm just questioning the language really. Where it says it is alleged that there is an error in the decision made, and I'm just trying to think, does that have any? I mean, it's kind of broad, and I'm just wondering, does this have any kind of specific with regard to establishing an error? I mean, an error versus a difference in interpretation, or just in terms of if you're appealing the decision of the arborist or whatever, or do all these things that we decide the 7 criteria is to establish whether an error is made? I'm maybe just getting wrapped around the axle of that a little bit.
So yeah, I mean, the word error does mean, it's common meaning that there was an error made. So as we discussed in an appeal, somebody is saying, no offense, Liz, but somebody is saying Liz messed up. She made an error. She should have granted this permit. And it's not always that the owner and Liz are real adversarial. But the basis of an appeal is a person saying, an applicant saying that they disagree with the decision of the city arborist, and they would like you to review it to determine if she did make an error. And the error would be that here, number 4 of the 7 criteria applies in my circumstances, and she concluded that it doesn't apply. In that instance, then it is going to come down to a matter of interpretation, where the Parks and Shade Tree Commission is going to have to look at criteria number 4 and interpret it. And you could come to a conclusion different than Liz's. I mean, it talks about in number 4 about threatening safety or property. Well, to what degree? I mean, every tree has some inherent, creates some inherent threat to that property somehow. I mean, every tree, somebody could be walking under it. You perhaps don't know that a branch has died and it could fall. It's very, very, very unlikely. And Liz is going to conclude, no, this tree does not create that kind of harm that number 4 is talking about. But you as a commission could, take a second look at it. Maybe you look more closely. Maybe you learn more about the tree because the applicant now is willing to put more on the record because they've realized that Liz has denied it. And maybe you do get to a point where you say, oh, yeah, that's a large limb. It really is about to come down. It could create, in that case, of course, you wouldn't take down the whole tree, just remove the limb, but you could come to a different conclusion is all I'm saying, based upon evidence that's put into the record. But it is truly, Mr. Chair, a question of was there an error made? It's maybe a little bit unfair to say error because Liz might not have.
It just seemed kind of loaded to me. So.
Yeah. I mean, Liz might not have all of the information. I mean, she makes the decision based upon what's given to her in the application. And by the time it gets to you, they may develop the record more fully and have a tree expert opine on it and do those sorts of things that could sway you the other direction. So it's not that she made an error. Maybe the record wasn't fully developed before her. But the use of the word error is really, should the permit have been issued based upon what we're now presenting to you. As a
Okay.
commission.
That helped.
Anybody else?
No, I would go along with Rachel, though. I think it really is important to go visit the property because I had an idea in my head and then I've gone to see the property and I have a whole different vision. So I think it's almost impossible to really make a good decision if you haven't visited the property.
Right.
I concur. I think it's always helpful. So.
That unfortunately has been a bit controversial though. So I'm glad everyone is on the same page. That's good.
Right. Right. Liz, anything else that you want to be sure that the commission knows?
I'm going to say the only question I would have about the inspections, there is something in the code where the filing of a tree permit application gives the city the right to inspect it. So would that not include the members of the commission? The city would just be city staff?
Yeah,
Let me see if I can.
that section specifically addresses the request for the tree removal permit, right? Yeah, so I think it does give staff, because at that point you're being authorized through the permit request process. You're being authorized to review the property, but at an appellate level, I always advise against going on the property without specific authorization from the owner.
Yeah. Okay. I think most of the time they can see it from the road, but I could see that being an issue if it was a backyard tree.
Right.
Or really, to be honest, the number one thing they teach you in tree risk assessment is do a 360 of the tree. So if the tree's on their property, they've got to walk on the property.
Yeah.
So that kind of is a problem. Okay.
There's no prohibition to knock on the door if you wanted to, right? I mean, that's not really.
No, that's right. There's not, just be careful, as I said, to not get into a conversation about the merits of the.
Right.
Well, and then I can tell you there's, when I go for just my regular inspections and stuff, there's almost never anybody home, to be honest with you. So that's certainly an issue if you guys need to get on the site. I'm trying to remember, didn't they do something years ago where they would like set up a time, all of them to go look at it, which I think is a problem unto itself, but.
Yeah, I really advise against these days.
Yeah.
Group site visits, because then you have to notice it as a public meeting of the body and the public's able to come, and it just gets too cumbersome.
Yeah. Okay. Well, I don't have anything else if nobody has any further questions.
So does the commission have anything on its agenda later this month?
Yes, we have a few deferred cases from the cancellation of the meetings.
That's right.
I think it's 2 street trees and a fee in lieu.
Okay. Good.
And that meeting is the 22nd, right?
I think that's right.
Pretty sure that's on my calendar.
Yeah.
Yeah.
At 10.
Let me see.
And have reports been submitted on them? I didn't check that, so that we would be reviewing, or just the report is submitted at the hearing.
Well, I've already done the reports because it was from a few months ago, so I'm not sure if Anne sends them out again, because obviously you wouldn't have gotten them.
Well, she's on the call. We could ask her to. Right?
I'm not sure what the protocol is, to be honest.
I'm not sure if she's listening or not. Anne, if you're there, are you going to be recirculating the? Oh yeah, she's on recirculating the reports.
Yes, I am.
There you go. Everybody will get the reports. Thank you, Anne.
Okay.
So everybody knows also that I'm available to you to the extent you have, questions about a conflict of interest, perhaps, or if you have just any kind of, question about whether you should be participating in a certain thing, or specific questions as it relates to a case and how the code should be interpreted. I'm available to you. I know none of you will abuse that and overuse me and run up big fees for the city, but I'm here for that purpose. Should you need me?
Okay.
Anything else?
I don't think so. I mean, the only thing I just wanted to add was, in addition to what was mentioned about the mayor and commissioners embarking on, a review, from what I gather, pretty conscientious and studied, revisit to the tree ordinance. So and just from what I've learned from speaking to some of the commissioners, that it's going to be a process that it's going to take some time, obviously. So I don't think it's something that we can wait for that to happen in order for us to proceed on something. I think we're going to have to continue the work here, and then if the ordinance is revised or whatever, then we'll just have to adapt to the new ordinance. But the only other thing I wanted to impart to everybody is that we're going to be part of that process. I think they're trying to do kind of include all the commissions and so forth who are involved, and get feedback from them. Which as I understand, this commission participated as well previously. But all I'm getting at is with this subsequent a review of it, we're probably going to be involved in it again. So, and from what I gather, we're going to be formally invited. I mean, I was just informally told about this, but I think we're going to be formally invited to our involvement. So,
yeah, I think that's right. You're not going to just get a revised code handed to you and say, there, now apply it. So I'm sure they'll seek your thoughts on any revisions they propose.
Okay.
Thank you, everybody.
Okay, thank you.
Liz, I have a question for you. Can you hear me?
Yes.
Okay. People ask me all the time if they have to get tree removal permits for crepe myrtles, and I say, well, probably.
Well, it is a tricky one because we know there's 30 species of crepe myrtles from about 1 foot tall up to 35 feet tall.
Right.
And then on top of that, it also depends on, in the past, they were, prior to me, even though crepe myrtles are not native, they were allowed to be planted. So if they had been planted as, say, the front yard tree, then they would 100% require a permit, but it usually ends up being a judgment call if they're 15 feet or taller, or that pretty much makes them a tree in the way the code is. And that kind of gives it a hard line. So the one caveat becomes when people start, let's say, pollarding them for to be nice in the way they're burned. But say somebody takes a Natchez that's supposed to be 30 feet tall and pollards it back to 10 feet. That's when it gets really tricky. So, but I always tell people it's $20 to submit an application. So for $20, you have your answer. Because if they don't need one, I'll review the application, do the site visit, and then say, you don't need a permit. So,
okay.
But most of the time it ends up needing it, frankly.
Okay. All right. Well, thank you. I appreciate that.
No problem.
I have one that looks like a tree. Like a real tree. So,
Yeah.
Okay.
Well, you'll laugh, but a lot of times for the surveyors, when they come out for new homes, they cite all the existing trees in the lot. And over the past few years, they've gotten, because if they're missing a tree, it's not shown on the survey, they're kind of in trouble. They have to go back and add it. So now, if anything, they'll tend to put really tall shrubs like a photinia that can get 30 feet tall, but is always a shrub. They'll put that on there as a tree. So you do have to be careful of that too. I've definitely had people submit tree permits for giant shrubs before. Better to be safe than sorry, though, right? Call and ask if you need a permit. I mean, it's like anything else. Ask if you need a permit and hope that you don't.
Right. Thanks, everybody. Mr. Chair, you
Do
can
we need a
adjourn the
motion
meeting.
to end the meeting? Do we need a motion to? end
No, you don't need one. You can adjourn it as the chair.
Okay, I declare an adjournment.
Thanks, everybody. We'll see you on the
Bye-bye.
22nd.
All right,
Okay.
thank you.
Thank you.
Nice to see everybody.